Okay, thank you very much. First off, I just want to say thank you for having me. It's a real honor, and it's a pleasure to be here. I know we talked a little bit about travel ban already and immigration. We're going to go deeper into that, but what I wanted to do first off to folks who are immigration attorneys or even non-immigration attorneys is sort of give you an overview of consular processing, especially as relates to Iranian applicants, and that'll sort of give you a good context to better understand the travel ban and what it is, what it isn't, and more specifically the waiver process, which is a uniquely consular process. So the more you understand generally about consular issues, I think it'll be better to understand the travel ban. First off, I think that for Iranians and Iranian applicants, the prior panel talked about how Iran is designated by the United States State Department as a state sponsor of terrorism, and that's just a fact. And other countries are North Korea, Sudan, Syria. And everything that the State Department does or consular officers do with regard to visa work or consular work is really seen through that prism of that designation. And it's really the reason why there's so much scrutiny on Iranian applicants and why they're sort of considered a special class and they have special treatment, I would say negative treatment, when it comes to visas. Before we get into that, I think it's also really important to sort of understand the human face of who actually are adjudicating visas, consular officers, essentially. Consular officers, I was a consular officer, I was a foreign service officer with the Department of State from 2006 to 2015, so almost 10 years, and did a significant amount of consular work as well. Consular officers basically are professionals that come from a wide swath of American society, all sorts of backgrounds. Most of them aren't even lawyers. I'd say maybe like 15, 20% of them are lawyers, highly professional. They go through an extremely competitive process to get into the Foreign Service, which is the diplomatic corps of the United States. What's interesting, most interesting though, is that consular officers, they come from this universe of people who are diplomats, who they get into the service, not necessarily to do consular work, but to, negotiate economic agreements or peace agreements or these sorts of things, be ambassadors. This is sort of what's in their heads when they're looking at the long terms of their career. But what is interesting is because there's so much need for consular officers out in the field at consular posts, embassies, and consulates abroad, they're actually required to do at least 1 and up to 4 years at the very beginning of their career in consular work, even if they're economic officers or political officers. So it's kind of interesting. It causes some frustration among officers that, maybe 20% of their initial career, they're doing something that they don't necessarily, or they didn't think they'd be doing, let's say that. In terms of the travel ban, an interesting comment I would make about, again, who consular officers are. When it first came out at the beginning of the Trump administration, you may or may not know this, but there was a lot of protest among Foreign Service officers and consular officers. I still know a lot of my former colleagues, and we're all on Facebook together and things like that. And social media was just plastered with all my former colleagues, commenting on it and having sort of negative impressions. And there's an official, what's known as a dissent channel in the Department of State, where I think more than 1,000 diplomats signed on to a dissent on the travel ban, basically criticizing it as, counter to U.S. policy, really. I'm trying to go fast because I usually do this in about an hour and a half, so I'm gonna speak fast, so I'm gonna sort of go from topic to topic. I hope you don't mind. So that's background. In terms of actual visas, since most people are not immigration attorneys here, for Iranians have sort of special treatment in terms of visa processing. There's 2 types of visas. There's an immigrant visa, which is, a visa that you get to come live in the United States and then you get a green card. Or there's a non-immigrant visa, which is, a visa for temporary, tourism or business. And also it could be a work authorization visa. So things like the H-1B, things like that people might know about. What's interesting is for Iranians, for immigrant visas, especially the ones that live in Iran, they can only apply for immigrant visas in Ankara, Abu Dhabi, and Yerevan. And there has been, and Elica will get into this with relation to the travel ban, but there has been sort of specialized workflows and processes with regard to the travel ban and just Iranians in general, because only these posts can see these folks, because that's just the way the workflow has been created in the State Department. And non-immigrant visas, Iranians can apply anywhere they're physically present. Although I think probably one of the biggest posts is probably Dubai, I think I would say.
Do they need to show that they're residing in the country, or could Iranians go on vacation to Spain and request a non-immigrant visa?
So you can actually, anywhere that you're physically present, that's what the rules say, you can apply. But because, and we'll get into this, but because Iranians are going to see very long delays in their visa processing, it should be a place that, they don't mind going back to, a couple times, a few times. Another really important point about just how the Department of State operates in general is about post management or consular post management. The Department of State, in terms of how they process visas, is a completely decentralized organization. Completely. There's 180 consular posts abroad, or around that number. And yeah, there's a central office that sort of dictates the general sort of initiatives they want, and and they explain, the law and things like that through a centralized system. But the way that each post processes visas, and this gets really important in terms of the travel ban, is up to the post and post management. Okay, so overview of the visa interview. Probably one of the things that people hear about, especially immigration attorneys, that they're aghast at, or people who are abroad and they know about the visa process, is this idea, especially for non-immigrant visas, that the interview lasts 2 minutes. And basically, the consular officer has to figure out everything they need to figure out in 2 minutes. Everybody knows about that? Is this surprising to anybody? Raise your hand if that's a surprising thing to you, that they have 2 minutes to figure out whether someone's eligible for a visa. Okay, well, everybody already knows this. Well, one person doesn't know it. It's surprising. It's surprising. So to give you sort of an idea of what a consular officer goes through, let's say just a typical tourist visa, not even Iranian, just let's completely simplify it. It's true, they have about 2 minutes to figure out, basically, the thing that they're trying to figure out for the most part in a typical case is, a tourist visa case, is whether or not they think that the person is going to come back to their country through, there's legal language for this, but I'm trying to simplify it as much as possible.
Just a quick note about that, because I get calls about this. Yeah. If you have a U.S. relative doesn't apply for them or send what's called, what the Iranians call a davatname, or a letter of recommendation of some sort. The person applies for their own tourist visa on their own, and they stand on their own merits.
Exactly right. It's all about the person, although who, if they have relatives in the U.S., things like that, that's something that is considered. It's usually not necessarily a positive factor, having people in the U.S.
Exactly.
Because again, they're looking at, will this person come back? So they're looking, what are their ties to their home country compared to their ties in, the United States? But again, going back to the consular officer and what they're dealing with, they have this extremely high workloads. Every day, they sit at their window and there's just a sea of people that they have to get through, essentially. Sort of like at the airport, where, just a ton of people, you have to get through all of these interviews, and you only have 2 minutes. And you're multitasking. You have to talk to them. You have to review their documents. You have to write your case notes. You have to look at security checks. You have to do all of these things in 2 minutes. It's something that actually, it's a skill, an acquired skill, that takes quite a while. I'd say it takes at least like 4 to 6 months to really get good at it. And to be able to sort of just be hitting on all cylinders.
Is this 2 minutes for non-immigrant visas only, or do green card immigrant visas get more time?
Yeah, green card and immigrant visas get more time. Okay. I'm just talking about the most typical type of case, which is the tourist visa. And this is average, essentially. So an average at your high workload posts. Okay, so again, going quick, giving you a macro view. The decision-making process. So this is like the ultimate black box. Nobody, everyone has a story, I think, of, a friend or a relative that got denied a visa, especially a tourist visa, and the consular officer just gave them a letter or something like that, and nobody knows what the reason was for the decision or anything like that. So 3 things can happen after your visa interview. You can get approved, which is great. Unfortunately, it actually doesn't happen for Iranians sort of at the window. Very rarely, I would say. Maybe sometimes, but very rarely, for reasons we'll discuss in a second. You can just get refused, and there's a lot of different reasons for refusals. The biggest reason, again, is what's known as INA 214B, which essentially just means the consular officer believes that you're an intending immigrant, that you're not going to come back. And maybe just a quick comment on this. It's really interesting how the law is set up, because it's actually the applicant's burden to prove to the consular officer that they're going to come back. So the starting point, essentially, the consular officer starts by thinking, you're coming to apply for this visa so that you can come and live in the United States, and you have to basically convince them otherwise. And that's just under the law. That's what it says. And then the last decision that could be made, and this is what applies to many Iranian applicants, is what's known as 221G, or administrative processing. And this is sort of the bane of the existence of all practitioners who deal with not only Iranians, but especially Iranian applicants. So how are we doing on time?
We're good on time. And the 221G is a lot of Iranians refer to as background checks or something. If
administrative processing.
Yeah, but in far Iranians call me like background check, or I have a background check. But it's
Okay.
administrative processing is much broader than that. It could be anything, really.
Yeah, so let's get into that then if we have a little bit more time. So administrative processing is just this umbrella term that means that they're putting a hold on your case. They don't tell you why, they don't tell you anything. But you can sort of read the tea leaves quite often and figure it out. It could mean, for example, that you need to give some additional documents. So they'll give you a letter saying, give us these documents, and then we'll continue processing your case. It could mean that they're investigating your case for some reason. Maybe they think there's some fraud involved in your case. And so that is an investigation that occurs at the consular post itself. Each consular post has what's known as a fraud prevention unit, which is usually headed up by, there's at least 1 or 2 Americans, and then probably like a staff of a few local employees who sort of understand country conditions. The fraud prevention unit is actually kind of interesting because it usually has extremely good ties to the host country and can find out a lot of things about the applicant and verify a lot of things about the applicant. For example, like when I was an officer in Mexico, on my first tour, and one of the things that I was always amazed at is that a lot of times people would come. The main thing we looked at to figure out if they wanted to come back or not is their economic situation. So they bring their bank account statements and say, look, here's my bank account. I have all this money. I have plenty of reasons to come back. But in Mexico, like in a lot of places, people can buy fraudulent documents across the street from the consulate. That's actually that's the place to buy, essentially. And we knew that as consular officers. And so when something, we were trained for sort of to identify if things look fishy. And so a lot of what we did, or some of what was done, was like verifying those bank statements. And one thing that I was surprised to learn is how good the ties were between our fraud prevention unit and all of the major banks in Mexico, to the point where, if we refer an applicant to the fraud prevention unit, within an hour, they could verify just by calling the bank manager or whoever the liaison was there at the bank and say, does this person have an account at your bank? And if they didn't, we found it out really quickly, and if they did, then,
Would you just deny it, or would you do a fraud finding for that? If you do fraud and misrepresentation,
Right.
that's going to stick with you for future requests.
Right, so this is called misrepresentation. So misrepresentation is actually a very interesting and nuanced kind of thing, but I would say that if the applicant, so I would ask the applicant, before I refer the case to the fraud prevention unit, I would ask the applicant, I would say, I think this is fraudulent.
Oh, okay.
do you agree with me that this is fraudulent, essentially? Do you admit that this is fraudulent? And sometimes they would just admit it, yeah, it's fraudulent, and then I would just deny them. But if they stuck to their guns, then, and I would tell them, if you force me to find out that this is fraudulent, then you're going to get misrepresentation.
Wow.
Because that's essentially how it works. Basically, you're supposed to give the person a chance to,
Come clean about it?
Yeah, essentially. But anyways, going back to admin processing, so that's sort of the internal investigation part that can happen. But for Iranians, the biggest piece is what's known as, like we said, background checks. The actual term is a security advisory opinion. And this is not even to do with the travel ban. So what's interesting, and what I think probably most people in this crowd know, but not everybody knows, is that, Iranians have been subject to, this increased scrutiny well before the travel ban. The travel ban has made things more difficult, but in terms of administrative processing, not a whole lot has actually changed, like qualitatively. Let's say maybe the processes have changed, but sort of, and the time that you're in administrative processing has sort of grown longer, but sort of the general concepts have been the same as applied to Iranian applicants. So we're going to talk about this later as well, and so I'll just sort of preview it. So one thing, when you do have these long delays, and they can last a long time. I mean, it's 6 months, a year. I mean, what it essentially happens is that the case goes into Washington through like an electronic cable, and it gets placed in the queue. And the interagency, you can guess who I'm talking about, the various agencies that have, US agencies that are interested in national security issues, because visas are a national security decision, they look at the person in depth, and until they clear them, nothing can happen. And a lot of times, these cases are just sitting. No one's actually working on them because there's a huge pile of similar cases that people are working on instead. And so that's why mandamus litigation, which I'm just going to touch on briefly, it could be a good solution for people that are in that spot because it can compel the government to actually make a decision. It can't compel them to issue, but it compels them to make a decision. And John and Ali will be talking about that later. The other thing I just want to touch on is sort of the difference between, in terms of what a consular officer does, in terms of the discretion they're allowed in their decision making. A lot of what an officer does is essentially they're making a gut decision, a gut call, factual determination. So again, going back to our 214B example, I'm talking to you for 2 minutes, and based on what you're telling me, I'm deciding whether you're going to come back or not, or whether you've met that burden or not. That's a completely factual determination that I've made, nothing to do with the law. There's no legal error or anything involved. Basically, consular officers have complete, broad, unfettered discretion to make that decision. There's absolutely nothing you can do to get that type of decision overturned.
And this is actually, I think Supreme Court has ruled on consular non-reviewability on these kind of decisions, or?
Well, most recently it was on an IV case. So I mean, the Supreme Court definitely, there have been rulings about this. There's sort of this jurisprudence that's been developed over time about consular non-reviewability, which has, the idea behind it was that, these applicants aren't here, they're abroad, and this jurisprudence developed 80 years ago. I don't know the exact numbers, but before the time of email and things like that, when consular posts were really remote. And so it didn't really make sense to, review decisions when, probably take a good month or two to hear about the decision, things like that. But things have changed, facts on the ground in terms of technology, but consular non-reviewability still exists. But it's being chipped away. It's definitely being chipped away. And so consular non-reviewability isn't this sort of ironclad rule anymore. But for factual determinations, it still is. So the main sort of challenge for a practitioner is the idea that legal errors that consular officers make, those can be challenged. And the Department of State actually has they have a system in place internally to challenge things that we think are legal errors in people's cases. Like maybe misrepresentation could potentially be a legal error. Or if they just apply the wrong standards, like on something like an investor visa, which is quite complicated. The thing to understand with consular officers is maybe that consular officer was their third day on the job and they don't know what they're doing, which happens. Everybody, you think of yourself on the first day of the job. You didn't know what you were doing in your job. You made mistakes all the time, and consular officers make mistakes too. So there are systems in place to try to address those mistakes. And of course, whenever there's a legal error and you have some other facts that are in your favor, there is a possibility for judicial review as well. So that's why I say there is some chipping away of consular non-reviewability. And the standard these days, last probably enunciated in Kerry versus Din, which is 2015-16 case, basically is that the language is that the decision needs to be facially legitimate and bona fide reason for the denial, which essentially means that the government's reasons for the denial must be legitimate on its face. So in other words, if the consular officer denies you based on a non-existent regulation, then it's not legitimate on its face. And the government must be acting in good faith on the facts. So for example, if the government says that you're a drug trafficker and you have reason to believe that they're not acting in good faith, then maybe you can challenge that. So, and we're going to talk about this. I want you to really understand and remember this standard, facially legitimate and bona fide, because it's going to tie into what we're going to talk about in a little bit about the travel ban as well. So I'm going to stop there.
Sure. So, with Elica, could you discuss more about what the travel ban is, what the actual prongs are, statistics, and Elica, go ahead. Thank you.
Sure. Great. So just a quick poll. How many people have worked on travel ban 3.0 waiver cases, just by a show of hand? Okay, 4 people. How many people have family and friends that are impacted by the ban? Okay, most people. So we've heard a lot about the ban from many different speakers and many different perspectives. But because it's been such a tsunami and it's so impactful for our communities and 3 different versions and all the different litigation, what we really wanted to do was make sure that everyone's on the same page about what the 3rd travel ban actually says, who it impacts and who's exempted by it. Because it was covered significantly on the last panel as well, we decided to shift a bit, and we're going to cover a lot of case examples so that we all walk away from this panel really understanding what the impact is, not just on our communities, but for other communities as well, which ties into this piece around coalition building, right, and how we work with other communities. Okay, so just to reground us, what is Travel Ban 3.0? Let's get on the same page. So a few key dates. We're not going to get into the first 2 versions and all the litigation. We're just going to focus on the 3rd version, which was introduced September of 2017, right? Then it was stopped from going into effect immediately. So in September of 2017, the law did not actually go into effect. Everybody with me? Okay. Seems like you are. Then what happened was, as the case was being litigated in court, in December of 2017, the Supreme Court lifted the injunction, right? They allowed the travel ban to go into effect until it issued its final decision, which was June 26th of this year, right? So Travel Ban 3.0 has actually been in effect from December 2017 until the Supreme Court decision in June, and that's a really important piece to remember. So what does it do, right? Like, for a while, does it impact green card holders? 1.0 did, like, we're not really sure. Are we impacted? Are we not impacted? So the 3rd version of the ban essentially indefinitely suspends the issuance of majority of visas for the countries listed in the proclamation or the travel ban, right? There are some exceptions, but those visas are indefinitely suspended unless you can show you qualify for a waiver. How many people heard, like, last night and on the panels before us about the waivers? Yes? Okay, a lot of people. So a waiver is basically like an exemption, right? It's a permission for the case to move forward, even though technically the ban is in effect. So I think it's actually counterintuitive because On one hand, the law is that you can apply, and many attorneys advise people to continue to apply for your families, et cetera, but the visas are actually suspended unless you qualify for this exemption. Yes? Okay. So what are the countries that are listed? The countries are Iran, Libya, Somalia, Syria, and Yemen. Those are the Muslim majority countries. North Korea is listed, but I think there's like 12 applications from North Korea, so the impact is very minimal. And then certain government officials from Venezuela. Chad was listed on the original third version from September 2017, but it was removed from the list, which shows that countries can be added and removed as well. So that's a function of how it works. So for Iranians specifically, what visas are we talking about that are impacted by the ban? All immigrant visas. All immigrant visas for Iranians, the travel ban applies.
And immigrant visas are green cards, essentially.
Right, so
permission to get a
immigrant
green card.
visas, I mean, the name kind of says it all. It's a visa for you to immigrate, right, to come to the United States to permanently reside, as David said, versus the non-immigrant visas, you don't have intent to come immigrate to the United States. The non-immigrant visas for Iranians are also suspended, but with a very important exception, which is student visas. So F students, J students, et cetera. Those are not suspended or impacted by the ban, but they're subjected to heightened scrutiny. Each country has a little bit of a different effect, but for Iranians, that's the scope of what we're talking about. I also want to make sure that folks are clear, because I think I get this question and you all get this question on a regular basis. People say, well, I have a close family member in the United States, or I have an invitation to come study or to work in the United States. Aren't I exempted from this? And the answer is no. Back in June of 2017, in the roller coaster of impact litigation that will just make our heads spin if we go into it, there was a time where the Supreme Court said, if you have qualifying close relationships, the ban does not apply to you. And a lot of our communities are still under this impression that as long as they have a US citizen parent or spouse or child here, that the ban doesn't apply to them, but it does. It applies to all immigrant visas. The other piece is that it applies to all cases that hadn't been adjudicated. So even if your interview took place before January 2017, you are subjected to the travel ban, right? Your case must go through this process. You must obtain a waiver, the exemption, in order for your case to move forward. So that's the scope of what travel ban is, but I find it pretty helpful to actually go through some examples just to really have it land. So here's a handful of them. If I'm an Iranian, I am engaged, I'm a US citizen here, and I'm engaged to Iranian abroad, my fiance is impacted by the travel ban. I need to get a waiver. So I cannot bring my fiance to the United States as a US citizen without a waiver. If I'm a US citizen or a green card holder and my spouse is abroad, I need to get a waiver because the travel ban applies to me. If I am a cancer patient from any other country, from Iran, right, and I've lined up medical care in the United States to treat my urgent needs around cancer treatment, I need to get a waiver in order to, because the travel ban applies to me. If I'm a citizen or a green card holder and I want my parents to come visit me because I've just had a child and I want them to meet my child and to be there, or if I want them to attend my wedding or to attend a funeral or a graduation, the travel ban applies. That's an example of non-immigrant visas. If I'm a dual citizen of, let's say, Iran and France, for example, and I apply with my French passport, right? So I go through the process, I'm a dual citizen, but I have a passport from one of the countries that is not listed on the ban, then the travel ban does not apply to me. So dual citizens are an exemption.
But you may still undergo administrative processing.
Yes. If I'm an investor, I want to come invest like $1 million in the United States economy. The travel ban applies to me. I need to get a waiver to do this. A few of the other exemptions though, right? So people who are not impacted, US citizens, of course, green card holders, dual citizens from a non-designated country, And then there's certain other exceptions for like people who already have travel documents, et cetera, that have been issued, but I don't think we need to get too granular on that. But those examples are pretty egregious, right? I mean, I think when you let them sink in about the scope of who is impacted by this, it's really detrimental to not just our community, but other communities. So we're gonna unpack the waiver a little bit, since we've been talking about it so much. So, okay, the waiver, the only hope to get a visa, right? What the government pinned so much of its argument in the Supreme Court on, which is the exception that allows the case to move forward. So there's 3 prongs to a waiver. You as an applicant have to show 3 things. You have to show first, a hardship to the person who needs the visa, right? A hardship to the family member or the individual abroad. I know that David will get into this, but it's a new standard, sort of, but in immigration law, so we're really not sure what undue hardship even means. So imagine trying to prove that to a consular officer in 2 minutes when you don't know what the standard is, right? The second prong is that you are not a national security threat or a threat to public safety. And the third is that it's in the national interest of the United States to admit you. So you have to show those 3 prongs. Everybody with me on the 3 prongs? Yes, great. So the burden, again, is on us as the applicants to prove that. So great, okay, I wanna bring my mom over for my wedding. I need to show that she qualifies for these 3 prongs. How do I do that? As you've heard on other panels, there is no form. There is no process where you can email or mail in documents, right? So attorneys are essentially just gleaning whatever they can from communal experience, different listservs, immigration associations, right? So it becomes, I mean, not only incredibly difficult and burdensome and stressful for the applicant, right? Because they don't know how to show that they qualify for a waiver, right? And many people had their interviews before this became the law of the land, so that's a big challenge. But as attorneys, I mean, there's so much division right now on what the strategy should be. Some attorneys will say, go to your interview. Some attorneys will say, don't go to your interview. And that largely depends on the group that you're representing. If I have a client from Yemen who's traveling through a war zone to get to a consulate where there's gonna be a 2-minute interview where they may or may not accept the documents, that's something you have to advise them on, and they have to make that risk, which I think is an impossible decision. But it's really difficult, I think, to advise and to guide and to be clients in these situations when there's such a chaotic and opaque process, which in fact has been what we've seen from December of 2017. So just a few case examples. So these are examples from the IABA cases and from the lawsuit that we'll talk about as well. But one example is a US citizen who sponsored her father to come help and to immigrate to the US and to be with them. He's fleeing a war zone in Yemen, and the interview happened before the travel ban went into effect, right? So when he went into his interview, he never had a chance to kind of show any facts or information about that. And then was denied, right? Right after the Supreme Court lifted the injunction in December, the visa was denied. And then, of course, they're in anguish about what to do. The father is stuck in Djibouti because for many of these countries, similar to Iran, there is no consul in the country, right? So you have to go to a third-party country, as David mentioned. So his visa's, the waiver is denied, so they're sitting there devastated, figuring out what to do, and then the consulate sends out an email that's like, actually, we're reconsidering you for a waiver. Okay, great, although the anguish of that. So they submit information for the waiver, and it's just pending, and so we don't know what's gonna happen in that case. Another example is a US citizen who has 2 US citizen children here, and his spouse is abroad and pending for almost a year now, waiting to see if the waiver is going to be granted or not. So during that time, they're not able to be together, right, for birthdays and for holidays, and they have to travel back and forth, which disrupts his job. The other case example I just wanted to raise to this admin processing piece, right, we don't know how long admin processing goes, and unfortunately, many of us have clients who the family members they're petitioning actually pass away waiting during admin processing. That is not uncommon to have your elderly relatives or clients who are in war zones actually pass away while you're waiting for administrative processing to clear and for the waiver. So it's been fairly detrimental. And again, these are all examples from the lawsuits that are challenging the waiver provisions that Babak talked about earlier, the lawsuits that are challenging implementation of the ban. We've talked a bit about the statistics already in other panels, so I'm not going to go back through the great efforts that Senator Van Hollen and Paya and Nayak and everyone did, but right, we're also layering onto the practice of the waivers the less than 2%, which I know is kind of we were talking about this earlier. It's kind of a difficult statistic. But another kind of rough statistics that we were just looking at yesterday is for Iranians specifically in 2017, about a little over 6,000 folks applied for immigrant visas. And it appears that in a 10-month period from December of 2017 to now, that approximately 514 have been granted. So that's a little over 6,000 over a one-year period in 2017 versus 514.
But those could also include dual nationals that wouldn't be susceptible to the waivers, is that
Right.
correct? Yeah.
Exactly.
So we don't know if the waivers were approved in those cases.
Exactly. So I think we want to leave more time for Q&A, but suffice to say that even with the decision, the really devastating decision by the Supreme Court, we've heard about so many different advocacy efforts to continue to challenge the ban, whether that's through the policies that were mentioned, asking for transparency around the statistics for the waiver. Senator Chu introduced a policy, again, to repeal the ban. There are at least 2 lawsuits, class actions, one that IABA is a part of, challenging the implementation of the waivers. And really importantly, both of those lawsuits represent individuals from all the impacted countries, not just Iranians. And I think that's incredibly important. The Yemeni community, other communities are very much devastated in the same way that the Iranian community is. And so I think this shift that we've been talking about, that it can't just be about our community, right? That we need to build coalitions, that we need to build allies, really permeates into every single layer of our legal advocacy and the cases that we take on. I think a lot about the first ban in the airport, right? And how many thousands of people turned up. And my view is that that outpour and the media attention, I think it did shift some of how the cases played out, right? The urgency around the injunctions, I think, were really apparent. So I think to the extent that we need to show up for other communities that are dealing with bans right now, right? Our issues around the travel ban is part of a larger struggle that immigrant communities, that our democracy is facing. So whether it's the ban or DACA or other issues, I think a big part of the travel ban advocacy moving forward has to be taking that into account at every single step of the way, even through the Know Your Rights and direct services that we do.
Well, thank you, Elica. David, did you have something you wanted to add?
Yeah, and I just wanted to reiterate one point that Elica made about the various prongs and sort of bring it back to how consular officers actually adjudicate these waivers. Essentially, there are 3 prongs: national interest, undue hardship, and national security. The way I look at it, though, is if you meet national interest and undue hardship, you've sort of done a lot of the work you can do as a lawyer. And then the case goes into admin processing for the national security prong, which you don't really have a whole lot of control over. From the point of view of the consular officer, though, sort of where they're making their factual determinations, similar to how I was talking about the tourist visa and 214B and thinking, the gut feeling of, is this person going to come back or not? The consular officer has a very similar role in the travel ban waiver in terms of deciding, essentially on the spot, with a gut feeling, whether or not something is an undue hardship or not. And there's been recent litigation, there's been where the government provided some of their guidance to consular officers about this undue hardship standard. Most of it was redacted, but there was some useful language that I think will actually be useful in litigation down the road. But the undue hardship standard, and listen to this because it's important, is, quote, an unusual situation that compels immediate travel by the applicant and that delaying visa issuance and the associated travel plans until after visa lifted would defeat the purpose of travel. So basically, in order to satisfy that undue hardship standard, and undue hardship, by the way, sounds like not that hard to overcome, like the word undue. There's different types of hardship standards, like extreme hardship in immigration practice, which are a lot easier to overcome than this, even though it sounds a lot worse. But this is really what the travel ban waiver, in my opinion at least, is all about. And so it's really important when you're putting together your waiver packages that they have to really be individualized. There has to be some kind of compelling hook, not only for the consular officer, but as laying sort of a groundwork and creating a record for potential litigation down the line. At my firm, first of all, I think all the class action litigation, it's amazing and fantastic, and there's been a lot of great progress and document productions because of it. But for us, we have a lot of clients that are more like the investor clients we talked about that have been our longtime clients and that are now facing this. And we're prepping them and having them understand that the travel ban waiver process, you can't look at it as a standalone process. This is a lead into potential litigation, individual litigation, where we think that there are actually a lot of potentially compelling arguments that can be made going back to the DIN standard about whether or not the travel ban and really the undue hardship itself is facially legitimate and bona fide, because it's really, the definition is inconsistent with the overall jurisprudence on hardship. And we think that the government is actually pretty vulnerable on that. And in an individual case, you might have better luck settling with the government on these types of travel ban cases, because if it's a class action affecting, thousands and thousands of people, the government's going to fight tooth and nail. But if you have an individual case and the government, it's just another case for the U.S. attorney, and if you're making all of these, novel, compelling arguments that they're going to have to fight, you might have a better chance at settlement. So that's really the points that I want to put across, is that, again, the consular officer is just intimately involved in this waiver process, essentially implementing it on a gut feeling. And to me, that's a little bit problematic. So actually, it's a lot problematic.
Thank you, David. So we're going to kind of switch gears and go into other immigration aspects with Ali. Ali, you have experience with asylum. You deal with these cases. Could you go over what asylum is? And, people call me from Turkey sometimes, and they want to hire someone for asylum, but they're really refugees. Could you explain the difference between asylum and refugees, and what asylum is and when they're here?
Of course. Hi, everybody. So refugee law essentially is different than asylum law, slightly, but major difference. So for asylum applicants have to be on U.S. soil or at the border, where refugees are just processed overseas through UNHCR. So essentially, if somebody has a fear of being in their country, let's say Iran, they go and register with UNHCR that has jurisdiction over Iran, which is in Turkey. So that's why there's a lot of refugee applicant population in Turkey. And then they go through the process there through the UN, and then they designate a country where they want to be resettled in. And if that's going to be the US, then it's going to be the US. Whereas asylum, like I said, you have to be on US soil or at the border seeking protection. Now, it's based on basically 5 grounds. Political opinion is the most popular, but also there's race, there's religion, nationality, and membership in a particular social group, or as they call it in Persian, ijtimai. And that just covers everybody. That covers the gay and lesbian people, that covers any particular group that can be defined, and whether it be any one of these 5 bases, the claim has to have a nexus, right? So they claim a credible fear of past persecution, so maybe something happened to them back home, or they have a credible fear of future persecution, that something's going to happen to them if they go back home. Now, and they can have multiple grounds, of course. The technicality for an asylum application is you have to make it within 1 year of arrival to the U.S. There are exceptions, such as if you have like lawful status, year 6, you can make that request. But by and large, most people, they come and they make that request. They should make that request within the 1 year if they come here as a tourist, for example. That's not going to last very long. Now, there are 2 types of asylum applications. There's affirmative asylum applications. That's the one that you make at the border or inside the U.S. within the 1 year. There's also defensive asylum applications, which are made once you're in removal proceedings. So if you are here without status and ICE issues a notice to appear to you and you have to go to immigration court, and a judge like Judge Tabador says, why are you here? You go, well, I'm afraid to go back to Iran, and you file your application with the court. That's a defensive asylum application. I want to give you some stats, and so going back to the refugee, I don't do refugee work. A lot of fantastic NGOs and other organizations such as HIAS, they do refugee work overseas. And I want to tie it to, again, what Judge Tabador said, which I was just sharing with my panelists. It really gave me goosebumps. Basically, I'm paraphrasing, but she said, everything that we know about America, everything that matters, right, that we've learned that it matters, it really doesn't matter if we don't protect the most vulnerable. And the most vulnerable are the refugees and asylum seekers because they have no right. So the coalition building, right, that everybody's talking today, rightfully so. We have, let's say, a caravan of refugees, poor people, people that have no other hope in their lives, really marching thousands of miles north with their kids in tow just to stay alive, right? And these, let's say, we don't actually have a accurate count, but let's say thousands of people are moving on foot towards the U.S. soil. It's important to have empathy because that's the coalition. Those are the people that we need to care about if we want to be cared about regarding the travel ban. And something that's a pet peeve of mine that when I hear within my own community, it doesn't matter because they're gays or lesbians. It doesn't matter because they're Arabs. It doesn't matter because they're Mexicans. That really should irritate every single one of us because they say the same thing. They will say it doesn't matter because they're Iranians. So just switch it and see how hurtful it can be. So stats. Right now, there's about, US was accepting about 110,000 to 50,000 refugees. It's cut it down. In 2018, it's going to be cut down further to 45,000, and I believe we've reached that cap already. In 2019, it's going to be cut down to 30,000. What that means is all of these people that have nowhere to go, they're essentially trapped in a cage in Turkey or other UNHCR facilities all over the world. Only 30,000 get to potentially be resettled here. That's after travel ban does apply to refugees. So it would be, they would need a waiver. With no resources, they would still need a waiver. Just comparatively, George Bush, his limit was 80,000 refugees. President Carter had 14,000, he admitted 14,000 refugees a month after US withdrew from Southeast Asia. And up until 2019, we received 1.25 million Vietnamese, Cambodians, Laotians, and other Southeast Asia citizens. So the reason the stats are important, just compared to what's happening today, we have to care for this caravan that's coming through. Now, I was touched. There was an LGBT component to this caravan, that they were even scared of their fellow caravan marchers, and they splintered off. And they arrived earlier. And the listservs that Elica was talking about, there's million listservs within the immigration space, which is amazing by itself. But I was just touched at how many non-LGBT organizations were recruiting Spanish-speaking attorneys to go to the border to see if the refugees have a credible claim. Because the process then at the border, what you hear from the government, from our government, is not true. Claiming asylum is 100% legal. It's what they're saying, that it's, it's just garbage. It's just pure garbage. So whether it's at the port of entry or not a port of entry, it is legal to apply for asylum. What happens though, procedurally, they go, they have what's called a credible fear interview. An immigration officer listens to their story to see if everything adds up. If everything adds up, they are said to have passed the credible fear interview. They're placed in proceedings and often in detention, and they're allowed to apply for asylum before an immigration judge. An immigration judge, after evaluating all the facts and evidence, he or she can make that decision whether that person ultimately is going to be allowed to stay as an asylee. If they're detained, they also have the opportunity to have a bond hearing. That's their right. Unfortunately, though, the bond amounts are sometimes just way high. It can be, from a couple of thousand to 20. The largest I've had is 25,000. I don't know, 50? Yeah. So, that's essentially an order that you cannot get out of jail. But so the advantage of staying in jail while the asylum application is going on is you get a more speedy kind of a decision, because you are detained and it's costing the government a lot of money to keep you detained. So that can be a plus. Of course, the negative is that you might lose. But if you are released, if you're within the general population, at our firm, we're getting final court hearings in 2020, 2022. I think that's pretty normal. And even that, you heard what Judge Tabador said as far as the backlog. Those are all pretty much, you get your hearing and it's parked somewhere until 2022, and then you go and you probably get another date. So the system is broken. I think it's really, they're aiming for it to be broken. I don't think anybody is, even pretending that they're going to solve the problem. We're happy that Jeff Sessions is out. We're mortified as to who's going to replace Jeff Sessions. Yeah, does that answer your question, John?
It definitely does. Removal proceedings used to be called deportation, and I read a stat that the backlog is 1 million cases right now. And no matter how many judges they throw in there, I'm not sure how they're going to deal with it. And some judges that recently they're bringing on are people with no experience in immigration law. And it's pretty much the most complex area of law, with all respect to other areas of law here. Immigration a lot of times doesn't make sense because it's so political, it changes constantly. So it's a nightmare for people dealing with these issues. It's just really sad at the end of the day. But we kind of started the process from someone trying to get in the U.S., and then they get status, either family-based, employment, or through asylum, eventually get a green card, and after a couple of years, they want to file for citizenship and become U.S. citizens. There's a recent case of a woman who was on Iranian television who was acting like a lawyer, semi-notario, was finally busted. She was actually taking on naturalization citizenship cases and taking people who couldn't speak English, which is one of the requirements for citizenship, and paying off the officer, or if they weren't in the U.S. long enough to be able to get it, paying him off, bribing them, I think $1,000 a piece, to approve the cases. And they finally got her, and she's going to get, I think, a year of jail. I'm kind of thankful for that. I've had so many clients come in and say, my friend got approved like this. I'm like, that's impossible. How is that possible? Well, that's how it's possible. It's corruption. Unfortunately, the government didn't put the names of the USCIS officers, the Immigration Department. I think they should be getting 10 times whatever she did for their corruption, but, insider games, they help themselves a little more. But to talk about citizenship, I'm glad Kousha is here because the volume he does with Parse Equality Center is really important to see what he sees and the issues that Iranians have. And frankly, a lot of your grandmothers and parents will be going through this, and they'll say, the English situation is a big issue, getting a medical exemption for it, or how often they could be here because they constantly travel to Iran, come back for 2 days and then travel again. It's not okay if you constantly are not here, but you come in every 175 days or before 100. These myths and misnomers that we really have to educate people on. But thank you, Kousha. Could you express more about that?
Okay, so I'm just going to go briefly talking about one of the main requirements of the continuous physical presence for the purposes of naturalization. So just a quick overview, in order to apply for naturalization, you have to be 18 and over, you have to be a legal permanent resident, and you have to be a resident of the state that you're applying for at least 3 months, be able to read and write English, and of course the fifth prong or element is the fact that the applicant needs to be continuously present for 5 years or half of that, which is 913 days, in order to apply for citizenship. Of course, there are exceptions to it. I mean, if you're married to a U.S. citizen, you need to be present for half of that. But in our experience at PARS, because we do high volume of naturalization, we have come to learn a pattern of problems that most of our clients have. And these kind of are tailored to people who have gotten their green card through diversity visa or through family petition, and they're brought here. And they still maintain some sort of a residence in their home country in Iran. So just going quickly, in order to apply for naturalization, the applicant who's a green card holder needs to be present in the U.S. for at least 913 days, which is equivalent to half of the 5 years. Now, I'm going to talk more about the myths and the issues that we run into. Number one, please tell your client that the USCIS does know your client's entry and exit dates. I mean, I cannot emphasize the number of cases I've seen that, oh yeah, I'll just put a different date or something.
And that's even if they exit on land border in Canada or Mexico, they know these dates exactly. I can't count
I mean,
this.
thank you, John. And for immigration attorneys that do naturalization and all that, of course, one of the ways is to get their passport, your client's passport, go to the website where it says on USCIS, locate my I-94 or view my travel history, and make sure that those dates are correct. Because, again, like there is this presumption that the officers that is going to adjudicate your case, they don't know anything. They do know everything. I mean, because when you enter the U.S., you get fingerprinted, you're subject to inspection and all that. So the dates must be correct, because if we have seen that for the clients that that had previously applied for naturalization, and they had previously lied in their application about the dates. When they apply again, they go to an interview. Some of the officers are asking, why did you not disclose the correct dates? We've had that a lot. So, and a couple other things. When USCIS receives your client's naturalization application, the clock stops. I mean, your client needs to know that. From that date, they're not accumulating any more, travel. So any more dates to which would add to their physical presence. And okay. So another myth that is, and because me and John were talking yesterday, and we really want to talk about exactly what are the issues. So a lot of Iranians or people in the Iranian community are under this impression that if they have obtained a re-entry permit, all the days that they have been in the U.S. are gone. I mean, I really don't understand how this comes about because the reentry permit, which allows the applicant to hold on to their green card in case if they're out of country for more than 8 months, 1 year or so, actually allows you to come back to the US. So that actually holds your green card. So if you have a client that travels a lot, definitely advise them to obtain a reentry permit. And especially with the recent, with the Trump administration, I've seen a lot more Iranian clients, to be subject to more scrutiny when they come by the border, when they're coming back to US and they had trips for more than like 8 or 9 months. So definitely that's something to advise your client on. And okay, in the INA, it says that if you're a legal permanent resident, you're allowed to take trips out of the country for less than 6 months. So your client comes to your office and says, okay, it's been 5 years. I had my it's been 5 years. I had my green card. Now I'm ready to apply. So I tell them, okay, can I see your trips? Client has 5 trips. They're all like 175 days. And they're like, okay, no, well, I was told that if I come back, under 6 months, I'm able to apply for citizenship, I should be okay. The answer is no, not necessarily. Because in the USCIS policy manual, it states that officers may actually review whether an applicant with multiple trips lasting less than 6 months had a requisite continuous residence and whether the applicant's principal dwelling place was in fact in the United States. In so many words, the officer can request information or proof that the applicant needs to show that they have been living in the US or they have maintained their ties to US. So I tell my clients, I'm like, so how, what do you mean? What is that? What do you exactly mean by this? So I tell them, let me just give you a hypothetical, and this is what the exact officer wants to know. So if, for example, I'm working for you, will you give me a month off to go on a vacation? Client says yes. I'm like, well, will you give me 6 months? She's like, no. I'm like, that's exactly what they want to know. In order for, if you have 10 trips and each trip is like 2 weeks or 1 week or something, the officer is going to be more inclined to accept that, those trips were for tourist purposes or you want to go visit your family. But if you have 5 trips that are all less than 6 months for like 175 days, it kind of, shows that you were working or living in Iran or your home country. So just because they've been out for less than 6 months doesn't necessarily mean that USCIS is going to adjudicate their case and grant their naturalization. Now, for trips that were for more than 6 months, less than 1 year, that automatically creates a presumption that the applicant had some sort of an intent to kind of abandon their status in the US. So if the applicant is ready to apply for naturalization and they have like 3 trips that are like for 8-9 months, when they go to the interview, for the most part, the officer is like, okay, everything looks good, but you had too many trips. Then they get a RFE, and in the RFE, a request for additional evidence, and the applicant has to show that they have maintained their ties. Now, as soon as, it's another funny story, as soon as I get a client and I tell them, like, I review their trip history, I'm like, okay, so what happened? I mean, how come you had like, all these trips that were more than 6 months? And they all say, well, my mom was sick. So USCIS is completely aware that every Iranian applicant who's been out of country for more than 6 months definitely had a sick relative. So they know that. You don't need to tell them. But just joking aside, USCIS, the officers, they don't care much as to why the applicant left the country. They want the applicant to show that they continue to maintain their ties to U.S. So that, the way you can show that is you can show it through various documents like mortgage, rental, tax returns, and there's like a list of documents that you can show that this particular applicant maintained their ties. Now, for trips that occur for more than 1 year, that automatically breaks the continuous physical presence. And so, for example, if a client goes out for 1 year and they come back in, they have to wait for 4 years and 1 day in order to apply for citizenship again. So that's that's a kind of a tough standard to break. There are some exceptions for that, but and this standard is not only applicable to people. So if the applicant got their green card through marriage through a U.S. citizen, because they're subject to the 3 years before applying for citizenship, if they have a trip for more than 1 year, they have to wait 2 years and 1 day. And if they're regular green card holders and they got their green card through family or refugee or whatever, they have to wait 4 years and 1 day. We had a few cases where we applied for naturalization for people who were out of the country for more than 1 year. We had an applicant who was actually stuck in Iran because his green card was stolen. You know, I personally went to the interview in Chatsworth with the officer, and for some reason, somehow we got an actually Iranian USCIS officer.
Like good or bad?
Yeah. And right on the start, I told him, I was like, listen, he has these trips. And he's like, you know what? We get a lot of Iranian Iranian applicants who do not disclose their trips.
Yeah.
I mean, this actually came from an Iranian officer at Chatsworth, who was mostly in charge of adjudicating naturalization applications. So it's very essential that, you know, the dates are, you know, you really review your client's case before having them apply for citizenship. And with that, I'm
Yeah, thank you, Kousha. Thank you so much for on the panel. Appreciate that. We're going to open up to any questions you have.
Wait, I think we should do a couple questions.
No time or?
Well, I think it's going to be very hard not to give this panel a question, so we'll take one question.
I guess a gentleman raised his hand really high in the back, or is there someone else that, but, yeah.
Thank you so much. I've had this eternal question since I applied for my student visa a while ago, long time ago, that as a person who lived in Iran, I mean, born, raised, whatever, what does the U.S. government check when it goes for the clearance process? I mean, what kind of information do they have to check on me or a person like me?
I mean, it could be anything that's available to them through the interagency. So it's kind of like the old CIA is going to come after you kind of things. But it depends on how much public presence you have. But you would, to a certain extent, know more than I do.
To be honest, I don't, because even from a consular officer point of view, you know, when the cable gets sent, it's all just through the internal system. It's a black box to consular officers as well. They just wait and the answer comes back. But I mean, just think about, I mean, I don't know when you got your student visa, probably many years ago, that then there was less information. But we live in a different time now. I mean, there's a reason, maybe I'm getting a little conspiracy theory here, but you know, there's a reason why the US government has purchased, you know, these huge warehouses in Utah for cloud services for their own, you know, for their own purposes, because there's a lot of data out there, and society is changing, and you know, I think anything the government can use to sort of cross-check against applicants they're using. That's the reason why you have this extreme vetting now go into place, where they're asking not just Iranians, but anybody that they want to for 15 years of all of their information, including social media handles, including phone numbers. That goes into the, you know, into the database. You know, who uses Alexa? I mean, this is really conspiracy theory, but I mean, we're all giving all of our information away, you know, about anything we do. And I have no doubt that, you know, the government has a lot of information out there. They have algorithms that they use to data mine it, and then they cross-check it against people who are trying to visit the United States. Even as a consular officer, I can't confirm to you, this is exactly how they do it because consular officers aren't privy to that. But common sense just tells you that there's an enormous amount of information out there, and it's growing every single day.
Plus Iranians, a lot of them are Muhammad Ali, and they all have the same name, so they have to
Yes. Can I help you?
Sorry, Kitty.
Yes, my question is related to the practice of with these waivers in these travel ban cases. I know that when we were waiting for the Supreme Court to come down with their decision, there was a lot of talk about let's cancel these appointments that were really close. That's something that I did. I had a interview scheduled for the beginning of July. Is it really now a strategy to kind of extend these cases as much as you can? I mean, trying to tell a family that I know you waited 15 years for your petition from your sibling to be approved, but guess what? Now it's just going to die is awful. How long can we, extend these out without it getting lost somewhere in the consulate?
I mean, if you notify the consulate, you could kind of keep extending it as long as you keep the NBC kind of situation pending with it. You got to contact them or something.
I mean, a 212F denial is not supposed to kill the case. It's sort of like a temporary denial because the travel ban is, the issue more is sort of a procedural issue of, let's say down the line things change politically and there's no more travel ban. How procedurally do you revive this case and sort of balance that against just delaying it so that it remains on the consulate's radar versus trying to somehow bring it back? But I mean, I'm confident actually that the State Department is aware of this issue. I think it's a very challenging issue, but they're not killing these cases. It's not like 212F is not a reason for a petition revocation. Let's just put it that way. And I think State Department has even commented on the DOS Q&As that that come out either not on the last one but one before that it doesn't revoke the petition. So
That's interesting.
So I look at the cases like on a case-by-case basis. If somebody's dying, then you want that case to be adjudicated as soon as possible. If somebody's just for the heck of it wants to move here, then maybe they should wait. But the other aspect of it is, I mean, really you have to advocate, get to know your congresspersons. This is not a matter of, and so I do a lot of advocacy, and it's not a matter of, oh, I'm Iranian, feel sorry for me, this is so not fair. That is true, but it's really a matter of civil rights. That congressperson is representing you, every single one of you, and they need to know that come election time, you will vote the other way. And if they know this, they will act accordingly. So the concept of, oh, pity me, it just doesn't go far.
I mean, we were at a conference, 2 weeks ago with like 350 immigration lawyers. I think there's still a huge split, and it's completely case by case, right? So what you do for your Yemeni cases versus your Iranian cases, I mean, it's all really dependent on where the consulate is for sure. But I do think we got so much more information about what undue hardship even means through the different FOIA documents, right? So I think there's a group of attorneys that are like, well, I'm going to keep pushing this out until I see what comes up with the litigation, right? Until we put more pressure on the Department of State. And there's a group of attorneys that are like, you know what? My client is like stuck in this third country, and so I'm not going to delay the interview anymore, right? Like as Ali was saying, for those purposes, just go ahead and schedule it.
The other consideration is I think you have to gauge your client's interest in litigating their case.
Yep.
I mean, individual litigation, because, if they actually are interested in that and have the means for that, then, full steam ahead. You want to get that denial as soon as possible.